Hello, good afternoon. I'm Stephen Tromans. I'm chairing this webinar on energy regulation this evening. Welcome to you all. We've got a very good number of you who are joining us, and I'll go through the batting order in a moment, but you'll see we've got the people involved up on the screen. That's not in order of appearance, it's in order of seniority. Nigel will be joining us for the panel discussion at the end. So if we could go on to the next slide, please, Katherine. Catherine's kindly operating the slides for us. That's the format. So I'm going to say a few words by way of introduction. Dan is going to deal with a general case law update on energy regulation. Katherine is then going to focus on Article 1 of First Protocol issues, and we're going to leave some time for a panel discussion and questions. We will finish sometime between 5:30 and 5:45, depending on how many questions there are. Many of you I know will have previously participated in these events, so you'll know that you can ask questions as you go along using the chat function on Zoom. If you put your question up on that, we will either try and answer it as we go along, or we'll answer it in the questions at the end. And finally, the slides, which you'll see, we will make those available to you tomorrow, I think. I should just add before we start that 2022 is an auspicious year because it marks 20 years since I and others joined 39 Essex Street, as it then was, and set up an environment and planning group. So we need to have a celebration, I think, at some time this year. Anyway, I'll move on to the introduction, if I may. So next slide. This is obviously a very timely event. You can't have failed to notice, I think, that energy regulation is an extremely hot topic in the news at the moment. So a great furore about not only domestic but also industrial energy bills. We've had the spectacle of 29 suppliers failing since the start of 2021. There's the constant issue of the difficulty and the cost of meeting the government's net zero commitments and obligations. And recently we've seen calls for a windfall tax on gas companies in the light of the extraordinary profits which they're making. And of course, we can't ignore the fact, with international relations being as they are, the great risk there is internationally to gas supplies in the event of conflict or sanctions occurring with Russia. So there's a great deal to think about. Some of you may have watched, I guess, or read about the proceedings of the Bays Select Committee yesterday, I believe, when the CEO of offgem, Jonathan Brearley, was agreeing that a lot needs to change in terms of regulation, in particular the stress testing of companies coming into the market to avoid what we've seen in terms of huge numbers of suppliers failing economically. If we go on to the next slide, just a word on what is energy regulation. What is it we're talking about? Just to give us some context for today. I think there's a number of areas, some of them you may be more interested in than others, but it's a very broad spectrum, I would say, of types of regulation. So we have, of course, the economic regulation of suppliers of electricity and gas, and distributors of electricity and gas. We've had that in place since electricity privatisation, dealt with by offgem, and of course that's directly relevant to the question of the failure of suppliers economically that I've already mentioned. As part of that, we have social and economic regulation, and going with that, the various schemes and incentives in place to try and alleviate fuel poverty, to try and encourage more environmentally friendly and sustainable ways of people heating their homes and using energy. When I looked on the offgem website yesterday, there is still an extraordinary number of schemes and incentives which they administer, some of which are no longer functioning as open schemes, but still are operating for those who've already joined them. Not all of them, I would say, have been entirely successful, but there they are. They don't seem to have been designed, I must say, with any great coherence in mind. I think they are They are creatures of their day. They were created for a particular purpose by the government at that time. We also have the licensing of oil and gas exploration. That's an important part of energy regulation. And you will be aware, of course, of the controversy over the granting of various exploration licenses for fossil fuels in recent weeks. And I think I'm sure we will come on to that in the Q&A session. We also have the regulation in the sense of control of infrastructure and development that's necessary for energy. So new facilities, not only for, of course, production of energy, but also what goes with it in terms of carbon capture and storage and batteries, etc. And finally, we have the environmental regulation of emissions. Used to be sulfur and so on from coal-fired power stations. Now, of course, it's really focused on greenhouse gases, administered largely by the Environment Agency or its counterparts in Scotland and Wales. If we go on to the next slide, please. So I just wanted to say a little bit about pressures and conflicts to set the scene before we get into the meat of this. I think there are a number of pressures and conflicts which are playing around at the moment, which are I would say, in tension with each other. So consumer protection and prices, that's obviously great political importance. That's political dynamite for governments, protecting consumers against prices, what they would see as excessive prices of energy. That's plainly something which is existential as a threat to government in terms of vote losing. But longer term, of course, we also have the issue of security and resilience. We should be plainly doing more than we are to get in place the systems that we need for the future to ensure we are resilient in terms of energy supplies. We've unfortunately let things like gas storage go. We are no longer as resilient as we would have been 5 years ago. And finally, net zero and decarbonisation. And all of those, I think, play together with each other in interesting ways. They'll pull in different times at different strengths. And finally, underlying it all, of course, we have politics. It all can be derailed completely by political whim, it seems to me at the moment. So, we're seeing some Conservative MPs complaining bitterly to our embattled Prime Minister about the cost of net zero. Do we really want to go down this route? The Treasury, no doubt, has its views on that too. And it's interesting to compare, isn't it, what we've seen in relation to offshore oil and gas exploration as compared with the political decision not to allow fracking, hydraulic fracturing, and onshore gas exploration, which undoubtedly, whilst it may not be conducive to net zero, would have had a huge impact of benefit in terms of security and prices, I suspect. So a major decision for the government, and I think this will be an underlying theme of our discussions today, is really how far to intervene in the market. When Mrs. Thatcher privatised electricity in 1989, obviously it was all about market forces. The market was supposed to work for the benefit of everyone in an efficient way and make energy cheaper. And well, that plainly hasn't always happened. So there needs to be more robust scrutiny, it's accepted now, of suppliers, stress tests for their economic strength. It seems to me there's going to be an unacknowledged but huge need to intervene in two areas of electric vehicle charging and domestic heating decarbonisation. We're pinning a huge amount on people shifting to electric vehicles and shifting away from gas boilers to heat pumps, etc., in their homes. Unless that seems to me regulated in some way, it's very doubtful that the market is going to deliver in an acceptable way. And when you intervene, then plainly that inevitably means some people are going to win and some people are going to lose, which is what I think a lot of the case law is about. So with that introduction, we'll come back, I think, to some of those themes. I'm going to hand over now to Dan, who's going to give us a case law update. He will hand on in due course to Katherine, who will deal with Article 1 first protocol. So I'll shut up for now. I'll join you again in a while when we get on to Q&A.
Thank you very much, Stephen. And it's wonderful to have so many people with us. I am going to give the case law update. Just before I begin, I'll just apologise in advance in case you hear any shrieks from downstairs. I'm sure we've all become used in the pandemic to the occasional child shouting, but I do apologise if that does happen. I'm going to speak, next slide please, Katherine. I'm going to speak about the cases. As usual, the courts have been very busy in the last year or two. I'm going to deal with cases concerning offgem, first of all, the sectoral regulator. Then I'll move on to deal with a couple of cases involving the Oil and Gas Authority that was set up in 2015. Then I'll move on to speak about three examples of energy infrastructure cases involving the development consent regime under the Planning Act, and then end with some conclusions which we'll hopefully be able to pick up again at the end in the Q&A session. Thank you, Katherine. I'm afraid the pictures are not as inspiring as one might hope. You tend to either get energy infrastructure pictures, all of which look fairly similar, or logos. But anyway, if we could have the next slide. Thank you, Katherine. So leading into the pandemic and in 2019, there were three important successful challenges to offgem decisions. Many of you may remember some of these. The first was the Gwynty Moore challenge, and that involved the scope of Ofgem's expertise, and the court held in that case that their expertise did not extend to the key issue in the case, which was an issue around the appropriate insurance cover, and therefore the decision was quashed. The second case was the price cap case. This was the British Gas case. And in that case, the court granted a declaration in respect of what was described as a fundamentally flawed consultation assumption that had been in play in that case. And the third successful challenge to an Ofgem decision was that it was a Northern Irish case, the Greenbelt Northern Ireland Limited judicial review challenge involving the renewable heat incentive in Northern Ireland, in which Ofgem was held to have acted unlawfully by preventing unsuccessful applicants to the scheme from submitting further information at the review and appeal stages. Next slide. Thank you, Katherine. So that was obviously before the pandemic. So how has Ofgem fared since the pandemic? Well, there have been a few recent cases. Most recently, the Scottish Power case was handed down by the courts recently, a couple of weeks ago. And in this case, in the Scottish Power case, the claimant challenged Ofgem's decision not to authorise payment from the industry levy of around £3 million in respect of customer debt which had been incurred by Scottish Power upon taking its position as a supplier of last resort, but the customer and debt had been incurred after taking on that position. The challenge was brought on three grounds. The first was a composite ground that Ofgem had fettered its discretion. The second was, or rather acted unfairly. The second was that Ofgem's decision was irrational, and the third was that it was inadequately reasoned. And the key question in the case was whether Ofgem had closed its mind by making an in-principle decision that the costs were going to be outside the scope of the LRSP. Ofgem argued that the customer debt essentially was a matter of commercial risk and should not be subject to ultimately should not be paid ultimately or spread across ultimately consumers by way of the industry levy. The key issue really in the case was whether offgem had applied its guidance or policy correctly, and also whether it had an, as it were, bespoke internal policy in relation to this issue, which it hadn't communicated to Scottish Power. Now, it was heard. The claim was heard by Mrs. Justice Thornton, formerly of our chambers, of course, and she, she made some useful statements or reiterations, I suppose, of some key public law principles in this area. Next slide, please, Catherine. Thank you. It was common ground that policy must not be over rigid. So the question of whether Ofgem had fettered its discretion, Mrs. Justice Thornton reiterated really that there's nothing wrong with having a policy, and indeed a policy or a principle or a rule should usually is usually a help or a guide to the proper exercise of a discretionary power. The key thing really was that it should not be inflexible, so as not to allow for exceptions based on the specific circumstances of the particular issue at hand. Thank you, Catherine. So this was a useful quote or a reiteration of that principle. But critically, the court, Mrs. Justice Thornton's, held that this wasn't the case here. It was a novel situation, and Ofgem didn't have guidance that covered the situation perfectly. But notwithstanding the lack of a perfectly, or rather of an operative policy, Ofgem had canvassed alternative approaches and possible resolutions to the situation or to the application and to the costs which had arisen. It had applied its published criteria where it could. It had consulted properly, and there wasn't any attempt to create an inflexible rule. Essentially, it was a balancing exercise between the ability of suppliers of last resorts to recover legitimate costs and the wider interests of energy consumers. And in addition to the issue around policy, the judgment was a reinforcement of what we might think of as a typical approach to by the court to challenges to regulatory judgments, expert judgments on the basis of mixed application of policy and then application to the merits, if you like, or the specific circumstances, will usually fall within the broad discretion of an authority, unless there's a hard-edged or procedural public law error. The reasons challenge was dismissed as well, and the reasons were held to be adequate and intelligible. Mrs. Justice Thornton at paragraph 91 drew on recent case law and gave a useful formulation, I think, of the unreasonableness test. And she identified two aspects, the first being the famously high threshold that we're all familiar with, no doubt, whether a decision is within the reasonable range of decisions that might be open to a decision maker. And the second aspect being concerned with the process by which a decision was reached. And it's that second aspect that I think is probably the most fertile ground, or has shown itself in recent cases to be the most fertile ground for legal errors. A good example was the Havant Biogas case. This involved the renewables heat incentive and the decision by Ofgem to refuse 4 special purpose vehicles under the RHI as producers of biomethane for injection, due to the applications not having been properly made. The issue in the case involved differences of application and interpretation as between the 2011 regulations, and the 2018 regulations. Ofgem's decision had been based on an alleged absence of proposed process details, and in particular in relation to the amount of information that had been provided about third-party supply chains that would show that the provision was, as it were, secure in accordance with Ofgem's interpretation of the regulations. Mr. Justice Fordham in this case dismissed several of the grounds, but held in quite a fine-grained analysis that Ofgem's statutory review officer had made multiple errors in interpreting and applying the registration requirements. there were, among other things, a failure to refer to or apply relevant guidance, a confusion of the requirements that as they pertain to the registration on the one hand, and those applicable to ongoing obligations as after registration on the other. There were inadequate and unsupported conclusions, and a consistent misdirection that preconditions existed where they didn't under the applicable 2011 regulations. Mr. Justice Fordham gave also useful summation of his judgment at paragraph 89, and said it was no answer to say that the operative decision did no more than involve matters of, as it were, offgem's expertise, and therefore simply a matter of a reasonable judgment along a spectrum, but rather offgem needed to ask the right questions and needed to appreciate that certain features were not preconditions, and the evaluative judgment in play needed to be addressed having regard to applicable guidance. Thank you. I won't, another important case last year was the Gravis case. I'm not going to talk about this for very much because Katherine, I know, will come on to this in more detail, but this was a case in which Ofgem removed accreditation under the renewables obligation scheme. And the key issue was the effect on a third party subsequent purchaser of the site and therefore beneficiary of the accreditation in a context where there had been fraud in the accreditation process by the applicant. Sir Duncan Easley, coming out of retirement, held that the decision was proportionate and that critically, well, fundamentally, fraud couldn't be tolerated to ensure the continuing integrity and security of the scheme. But as I said, I'll let Katherine deal with that case in more detail. Just a quick, I thought I'd highlight quickly this case. It was an uncontested case, the utility point case. It was a case in which the court made declarations urgently that the energy supply companies were insolvent so that Ofgem could revoke their gas and electricity supply licenses. And I think it's notable, just for Mr. Justice Mead's comment, that urgency in dealing with these matters was justified to customers of the company, so that customers of the company can have a greater degree of reassurance about their position. And indeed, that greater reassurance can be given about the functioning of the energy markets generally. And if we needed it, it's a signal perhaps of the court's readiness to assist urgently when the energy market demands it. So turning then to oil and gas, as I say, there's a couple of important cases involving the Oil and Gas Authority. The first was the Cox challenge. This is a good example, a good recent example of the burgeoning or increasingly common climate, environmental, social and governance challenges, if you like, to aspects of the energy market. And this particular challenge was to revisions made by the Oil and Gas Authority to its maximising economic recovery strategy for the UK. The key issue was whether the statutory objective in the Petroleum Act, as amended, of maximising the economic recovery of petroleum is inconsistent with the government's net zero targets. The original strategy had been introduced as part or following the Wood Review reform proposals. The revised strategy was produced following a further review in 2020 to take account of the government's now 2050 net zero target. And the revised strategy came into force a year ago. The claimants' essential criticism was of the strategy's approach to the taxation of the oil and gas sector, which they criticised as being too generous. Sorry, next slide, please. The claimants argued that the new definition in this the new definition in the strategy was inconsistent with the Act's definition, and the results of the favourable tax treatment of oil and gas, or the assessment of the oil and gas sector on a pre-tax basis, had not been properly factored in. And the claimant argued that the result would be increased emissions from greater oil and gas extraction that would have been the case if a proper tax-related assessment had been made. The claimants also criticised a failure to take into account the so-called Scope 3 emissions, those that arise indirectly as a result of the strategy up and down the value chain. The defendants submitted successfully in the court, Mrs. Justice Cockerell accepted this, that the detailed assessment and definitions adopted through the strategy and critically the balancing, if you like, of these competing statutory objectives, net zero on the one hand and the need for maximising oil and gas resources on the other, were matters for the expert sectoral regulator, again subject only to rationality or reasonableness. Another brief a case I thought I'd briefly mention, as it may be of interest to some of those listening, was the AT case, the AT and Oil and Gas Authority case. This was interesting. It was an interim relief application, actually, but it was interesting because it was a good example of the court, if you like, delineating properly the respective jurisdictions in relation to the Oil and Gas Authority as between judicial review or the arbitration provisions within the petroleum licenses that were in issue. The Oil and Gas Authority wanted to issue a notice to third parties. The notice itself and its contents was confidential, but they wanted to issue a notice which the claimant thought would be prejudicial if it was issued to third parties. And the question was whether the decision could be challenged by way of an application for interim relief, as I say, under the arbitration provisions, or by way of JR. The court held that the matter related to a particular power that was conferred simply on the Oil and Gas Authority, and so judicial review was the only route. The relief was granted and the notice was held back on modified American cyanamide principles. I think it's a good example, though, as we're familiar with in other areas perhaps as well, of the court's flexibility sometimes in terms of ensuring that an application's substance will be considered even where the form may not be right. So turning then finally to infrastructure cases, there are three cases I wanted to discuss. Sorry, next slide, please, Katherine. Thank you. The first case was the tidal Lagoon case involving the development consent order covering Swansea Bay, which was made in 2015. The issue here was a sort of statutory construction argument, really, about the potentially conflicting definitions of begun, whether development was begun or whether it was commenced, and the distinction or the difference between the requirements of begun in the Planning Act 2008, sections 154 and 155, as opposed to the requirements for commencement in the 2015 Development Consent Order. The developer had not commenced in accordance with the definition of commencement within the order. It had only conducted surveys and investigatory works, which it wanted to argue would satisfy the requirement to have begun under the Act. And the question was whether the developer would be permitted to amend the order to reflect the more permissive concept in its own interpretation of begun. Now, the problem is that, the court held that it would be an unsatisfactory result if the developer's instruction the developer's construction was preferred, because it would extend the potential or prolong the risk of compulsory purchase, for example, which would be a threat, as it were, held over third parties. And also importantly, it would undermine the necessary certainty for limiting the duration of consents under the Planning Act. And so the challenge failed. The EFW case, now this was a challenge to the Secretary of State's refusal of a DCO for an energy from waste facility. This was an interesting case in that the existing facility had made 2 applications for consent, one of which fell within the criteria or met the thresholds for the development consent process, the other of which was below those thresholds and therefore did not. Clearly, as a result of that, one of the first application was covered by a national policy statement, but the second wasn't. The Secretary of State issued a direction that both could proceed together under the development consent order regime, but then also proceeded to assess it. The examining inspector assessed both applications under Section 104 of the Planning Act, which is a procedure where a national policy statement applied. Now, the court, Mr. Justice Dove in this case, held that while it was possible to include more than one project in a DCO process, including one that didn't on its own meet the thresholds, each must be examined properly in accordance with whether an NPS applied or not. So the Secretary of State or the inspector had acted unlawfully in proceeding with the examination on that basis. However, relief was refused because the court found that there was no material prejudice involved and the decision would have been the same in any event. Finally, then, the case of Pierce. Now, this was a case where the claimant challenged the grant of a DCO for a wind farm due to a failure to consider properly information on cumulative impacts of a similar nearby facility. Mr. Justice Holgate held that a decision maker mustn't grant a DCO without having proper information, subject, of course, to the constraints imposed on applicants or what they may reasonably be required to provide. And then, of course, once they are satisfied that they have sufficient information, they must evaluate that information properly. Those are essentially planning judgments that must be made according to the standard of Wensbury irrationality or unreasonableness. But here, the significant cumulative effects were acknowledged and were common ground, but the decision maker should have taken them into account and evaluated them, and the DCA was therefore quashed. So, in conclusion, just briefly, I mean, we'll obviously come back to some of these, no doubt, in our discussion, and Stephen's already touched on some. But I think 3 key themes emerge, and with the current context of the cost of living crisis and the recent COP26 and net zero issues very, very much alive. 3 key themes emerge from what I've discussed. I think the first are the ongoing tensions in almost every area of this of the law between energy need and needs and the environmental impacts and imperatives, if you like, or objectives of the transition to net zero. The second repeated theme, and again, unsurprising, obviously, but also almost always the central element in these cases, is the recurring battleground of Wensbury unreasonableness. And the third, and something that is no doubt going to grow, not least with forthcoming challenges, both in relation to COP26, would be the continuing importance and prominence of environmental, social and governance litigation and challenges to probably in most of the areas that Stephen identified at the start. And I think the critical question, or the interesting question in the coming months and years, will be how the courts respond as the crisis really grips. So I will end there. Thank you all for listening, and we'll obviously come back in our discussion, and I'll hand over to Katherine.
Thanks very much, Dan, and hello to everybody. I'm going to be talking about Article 1 of the first protocol, And that's not just because it's of academic interest, but really because it's becoming more and more important in this field of work. You might not think that human rights would really be relevant to the practice of an energy lawyer, but you would definitely be wrong about that. And as I hope will become clear, they really do offer some very significant financial remedies for clients in certain circumstances. So definitely worth being on top of this, not least because it seems to be, excuse me, a growing area and developing all the time. So what I thought I would do is begin with giving a general overview of the principles which relate to A1P1, so a bit of revision, I suppose, and then look at some of the cases where A1P1 has been relied on in the context of energy regulation. So what I'm going to do for my review is break it into 4 chunks. So I'll start by looking at the meaning of possessions, then look at interference, then justification, and then remedies. And just in case it's helpful, I've put there the wording of Article 1 of the first protocol so you can refresh your memory. So the first element then, you can't rely on A1P1 unless you can identify a possession. And it's not, we now know it's very clear from the authorities, it's not a possession under domestic law, and that may be something that's taken into account, but it's certainly not determinative. Possession in this context is an autonomous convention concept. So you need to be looking at the case law of the European Court on Human Rights, which now, of course, our courts have looked at and analysed. And I suppose the general point to bear in mind is that the concept has been widely interpreted. So we're not just talking about obvious possessions like freehold interest in land, for example, but it spans a whole range of possessions from the tangible to the intangible. So some examples in the energy regulation context, subsidies due under legislation. I mean, I've put Infinis as the example. I suppose, strictly speaking, I should have put a statutory right to accreditation, but certainly there are other cases. There's the wood boilers permission decision, which I'll come on to talk about. That definitely is going to come under the umbrella of a possession. Similarly, for concluded contract, contractual rights, marketable goodwill in a business will count as a possession, but importantly not the loss of future profits. Licenses will count as a possession. So if you need a license to carry out your business, you will be potentially in A1P1 territory. Legitimate expectations of obtaining a property rights will also be possessions. Interests in land, pretty obviously. And I've just added, given that we've heard various announcements from the government about new types of benefits to protect people from the expected increases in energy prices, I have just added there welfare benefits as well, because where benefits are provided for as of right under legislation, and whether they're contributory or non-contributory, they are also possessions under A1P1. And of course, that's one element. You have to identify the thing, but it can't just be a thing in isolation. I couldn't rely on A1P1 in respect of your house, for example. So clearly there has to be a degree of ownership. And normally in this context, in my experience, it's pretty obvious, but if it ever is something that you need to think about. I've put a quite useful Strasbourg case on this. You've got to ask whether in all the circumstances of the case have conferred on the applicant title to a substantive interest. So it's not literally title on a piece of paper, but whether in all the circumstances there's the requisite degree of ownership. And so what that means, taking a step back, if an accreditation is revoked by a regulator or a license, and clearly in the energy regulation context, that kind of thing happens all the time, we are in possession territory for A1P1 purposes. Similarly, if access to the grid is interfered with, or a decision by a public authority interferes with a completed sales contract, for example, for the sale of electricity, all of these types of decisions on the face of it are going to give rise to a potential claim. Obviously, that's not the end of the story. I'm going to go through the other requirements, but you should at least be capable of satisfying the possession requirement. So that's stage one. Then you've got to think about whether there has been an interference by a public authority. And it's often said, well, the Strasbourg Court's analysis, that there are 3 rules within A1P1. So there's the first rule, which is a general principle, and it's the principle of peaceful enjoyment of property. And to be honest, that's not particularly useful in itself, but it just informs the way in which the whole thing works. And then rules 2 and 3 are examples of specific types of interferences. So under rule 2, that's a prohibition on unlawful deprivation of property, so where you're completely deprived of your property. And rule 3 is the entitlement of the state to control the use of property in the general interest. So two types there of interference: deprivation of property, so taking it away, and then control on the use of property by the state, which is less extreme, obviously. And in recent cases, it seems that the courts aren't so interested in this sort of analysis. At least that's my reading of recent authorities. But it can be a useful thing to think about and draw to the court's attention, not least because there's the general principle is that a deprivation of property will be disproportionate and therefore unlawful if there is not compensation. So often, if you're acting for a challenger, you will want to try and frame the interference as a deprivation of property, because then it's going to be easier to establish a breach, which then gives rise to a financial remedy. But really, I mean, the interference part of this is probably the easiest aspect. It's not particularly difficult to show, and the courts are quite pragmatic about it. You just need to show a real world impact on the relevant possession, so effectively detrimental effect. So just I've given you one example from the Breyer case. It was accepted, this part of the analysis, it was accepted a government consultation resulted in an interference with possessions protected by A1P1 because, as a matter of fact, it did in a real and practical sense interfere with the claimant's businesses. Then we come on to justification, and I suppose this is where it gets really interesting, and all these different competing factors that Stephen and Dan mentioned come into play, and it's for the courts to weigh them against each other under the correct framework, which I'm going to talk you through now. Because, of course, this is a qualified right, it's not an absolute right. So it can be interfered with as long as the interference is justified. And to be justified, to be lawful, an interference has to have 3 elements. It has to be prescribed by law. So it's got to have a proper legal basis, whether that's typically in this context, it's some kind of secondary legislation, some sort of regulatory scheme, but it might be some sort of guidance or policy. So that's the first thing, prescribed by law. the interference has got to pursue a legitimate aim in the public interest. So that might be, for example, environmental protection, or it might be protection of consumers' interests, that sort of thing. And of course, and this is normally where the sticking point is, the interference has got to be proportionate. And that's often described in the authorities as striking a fair balance between the interests of the community and the rights of the individual. And so that often involves looking at whether the measure in question, so the interference, is suitable and appropriate to achieve the objective pursued, or whether the objective could be attained by a less onerous method. So is the authority using a sledgehammer to crack a nut? And as Dan mentioned, the margin of discretion, sometimes called deference, afforded to public bodies depends on the subject matter, but typically with expert regulators, the courts will be quite deferential. So they'll respect their judgment unless it's really manifestly unreasonable or disproportionate. And we know in particular that environmental protection is generally given a wide margin. So let's say you've established a breach, there's a disproportionate interference, and what can you then achieve for your client in terms of remedies? And I suppose really there are two broad types, and it will depend on the nature of your claim as to what you want and whether it matters. But if you're challenging legislation, it may be that you want to rely on Section 3 of the Human Rights Act to get the court to sign off, if you like, on a different interpretation of the legislation that avoids the human rights breach taking place. And that in some ways can be the most powerful remedy of all to a client, because it means effectively that the problem goes away. Looking forward, the legislation will be read in such a way that the breach is avoided altogether, and therefore their rights are protected. And if that's not possible, you could seek a declaration of incompatibility. But I mean, that's pretty unusual, not least because it really has very little value to the client beyond a political value, in the hope that Parliament would then step in and change the position. It's not in itself going to make the client's situation any better. So that's typically why it's so important to try and persuade the court that Section 3 can be applied in the context. And then, of course, damages. It's important to recognise Human Rights Act damages are discretionary. And the court will look to the Strasbourg principle of just satisfaction. So in all the circumstances, are damages necessary to afford just satisfaction? And I've put an extract there from the case of Anna Frigeva. It's often said in human rights cases that money is supposed to be of secondary importance. So often in human rights cases, a declaration is seen to be just satisfaction. It corrects the ill that the claimant has suffered. But this is a very particular context, energy regulation. And in this context, we've now got quite a body of authority precedent that has built up, showing that damages are typically awarded where there has been a breach of A1P1, and that breach has led to significant financial loss. And the way that damages are awarded in that context is it's on a restitutio in integrum basis. So I've put 3 examples there. First of all, the Infinis case, that was damages for a refusal to grant accreditations, and their damages were awarded on the basis of the company's actual loss. Similarly, in Brea, it's not an energy regulation case, but the Bank Melak case is another example of this sort of approach being taken. So you can see that there is scope for using a human rights argument to achieve a really significant financial remedy for your client, really just like any other sort of commercial litigation. In terms of causation, you'd have to show that the loss has been demonstrably and directly caused by the breach. So obviously you'd have to put in evidence to demonstrate that, and unsurprisingly, the applicant's expected to mitigate their loss. So again, you typically put in evidence to demonstrate what they've done to minimise the losses that they've experienced. But the other thing I just wanted to remind you of, the difficulties in assessment don't prevent the award of damages. Several cases have said that, but for example, Breyer. So just because it's a bit tricky to work out exactly what it should be, doesn't mean in itself that, that you won't get damages. I will whiz through some examples, and I'm mindful of the time, so it may be that, well, I will be quite quick, and for those that are interested, of course you've got the slides, which you can read at your leisure. So the Infinis case is really significant in terms of the development of A1P1 in the energy regulation context. And it was a challenge to the refusal to grant accreditation for renewables obligation certificates. And that had a monetary value in practice, because if the certificates had been granted, the recipient would have been entitled to avoid a charge, a hefty charge. And it doesn't really matter, I won't go into the details because I don't need to, but effectively the authority's position was that the power stations in question fell within an exception within the relevant statutory scheme. That was their interpretation and application of the statutory framework. But the claimants disagreed with that, and ultimately the courts disagreed with that approach as well, which meant that the refusal to grant these accreditations was found to be unlawful. And that then meant that there was a legitimate expectation of the right to accreditation arising under that statutory scheme. And that was held to be a possession for A1P1 purposes. And damages were awarded on the restitutio in integrum principle, given that the court said Infinis had been wrongly deprived of a pecuniary benefit to which it was entitled by statute, and also the lost benefit was readily calculable. So that was that case. Moving on to the actually, I'm going to skip out Drax Power because it's less important. The Npower case is quite an interesting one, not least because it contrasts so much with Infinis. It was a challenge to a direction from Ofcom that the claimant company had to conduct a trial with a large number of its customers, which involved the claimant company telling the customers that they could potentially save money by switching to another provider. Unsurprisingly, the company wasn't very happy about that. And one of their arguments was that the direction was an unlawful interference with the company's A1P1 rights. And there the court analysed the proportionality framework to give offgem a wide margin of discretion, and it found that a fair balance had been struck between the rights of the supplier and the interests of the community. And that was in circumstances where offgem had done research and they'd identified that there was a problem with a lack of consumer engagement in switching supplies. So you can see very different facts from the Infinis case. In the Infinis case, you've got a statutory entitlement to a particular, well, an accreditation, a possession, which of course has pecuniary value. So much less contentious, much more straightforward analysis, whereas here the court is having to weigh up really quite difficult competing factors that one would normally expect the decision maker to do in the first instance, and not for the court to interfere with, unless of course the Wednesbury unreasonable threshold is met, or there's no fair balance on a human rights analysis. I wanted to mention the wood boilers case. I'm I'm slightly biased because it was one of my cases and that I did with my colleague Duncan, and it's only a permission decision, but it is really interesting in terms of the legal analysis, and I think worth looking at if you do practice in this kind of law. It was a challenge to a decision by offgem to stop paying a particular type of subsidy. The claimants were two renewable energy companies, and they developed a model for the installation and maintenance of renewable boilers in domestic homes. And through that model, they received payments from offgem subsidies. And offgem had approved the model in question. They'd said it was compliant with the regulatory scheme, and they'd paid the subsidies for several years. And then offgem, well, suddenly, as my clients would have said, changed their position, and they stopped paying the subsidies on the basis that actually the model didn't comply with the regulatory scheme. And what was more, offgem said they didn't have the power to pay the subsidies to the claimants as it had been doing. And so it's a really interesting case because it's concerned with the position where giving effect to a legitimate expectation would be ultra vires. One of the arguments for the claimants was that the legitimate expectation of continued receipt of the subsidies, even if it was ultra vires for them to be made, was a possession for A1P1 purposes. And that possession had been interfered with by the refusal to give effect to the legitimate expectation. And it was a case where Section 3 of the Human Rights Act was being relied on for the statute to be read down to avoid that breach, effectively to allow the legitimate expectation to be given effect to, and or a claim for damages for the breach of A1P1. And those arguments were accepted as being arguable, permission was granted, and unusually there's a written judgment, which, as I say, the analysis might be useful for people in future. Unfortunately, well, unfortunately for the development of the law anyway, the claim never went to a final hearing, so we'll never know the court's final views on all of that. But as I say, useful analysis on some really tricky and interesting issues. And then finally, very quickly, the Gravis case, which is a very recent case that Dan touched on, a challenge to offgem's decision to withdraw the accreditation for a particular generating station. And the main argument was that the deprivation of the possession being the accreditation, was disproportionate and amounted to a breach of Article 1, Protocol 1. I wasn't involved in this case, and some of my colleagues were, and my reading of it from the judgment is that actually the point about the accreditation being a possession for A1P1 purposes was conceded, so Ofgem agreed that, and the court didn't indicate any concern with that sort of legal analysis. So quite useful in terms of possession analysis going forwards. But then the court went on to do its proportionality exercise. And as Dan said, effectively, the need to prevent fraud was so important that even if there was an interference with the rights of a third-party purchaser for value, the integrity of the subsidy system and the public acceptance of the cost meant that it was acceptable for Ofgem to take a zero tolerance approach to fraud. That brings me to the end. I just wanted to conclude by saying that A1P1 is capable of providing a really powerful remedy, both in financial terms, but also in terms of the reading down of legislation where that's relevant, in cases where it can be shown there's a clear entitlement to a financial benefit, a benefit of financial value, which is blocked by the action of a public authority. But I draw a distinction between those sorts of cases and cases where there's not a clear entitlement. There it's going to be difficult to establish, I would have thought, that there's been an interference with A1P1 rights, which is disproportionate. And so in those circumstances, even if you can establish a breach, I suspect that it would be difficult to obtain meaningful damages.
Great, thank you very much, Katherine. So I think if we can all perhaps come back online, and we've got 10-15 minutes for any questions or discussion. I'd just like to start by bringing in Nigel, who's been sitting very patiently listening to this. Really, by way of any complementary thoughts that you have, Nigel, on perhaps other uses of human rights other than Article 1 of the first protocol, because that whilst it's very important, isn't entirely the whole picture. So I'll give you the chance to say something on that, if I may.
Let me deal with, thank you, Stephen. Let me deal quickly with 2 points. I'm conscious that we are running out of time. Let me encourage, if I may, some deeper reading of 2 of the cases relied on by Dan, which deals with the topic of rationality and unreasonableness. The first is the Scottish Power case. That's Mrs. Justice Thornton. And the second is the decision of Mr. Justice Holgate in Pierce, which is the wind farm case, the last one Dan referred to. Now, I don't know whether either case has been appealed. I've assumed not. The Scottish Power case is helpful to illustrate 2 problems. One, it's a really good summary of the Wednesbury irrationality unreasonableness principle. It's in paragraph 91, which is in one of the slides. It's a near verbatim quote by Mrs. Justice Thornton from 2 earlier cases, the 2018 case of the Law Society and the Lord Chancellor, which was then endorsed, as mentioned, by Mrs. Justice Holgate in the 2020 Work and Pensions case, the Johnson case at paragraph 48. So it's a helpful summary, particularly for the second part of Wednesbury. Wednesbury has been bouncing around since 1948, whenever it is, and it's always been slightly difficult to grab hold of. But what's important in that case is the issue that has also been touched on by Dan and Katherine, that even if you have a clear statement of Wednesbury, then you have a problem if in regulation cases, not just energy regulation, but regulation across the board. And it's known to some as the CELCOM trap, that's CELLCOM. And this is that the Wednesbury test in specialist regulation cases is subject to a higher or different standard of review, and the court, as in the proportionality cases, has a wide margin of appreciation. And you'll find that developed by Mrs. Justice Thornton in paragraphs 92 to 98. In the Pierce case, again, there's an important summary of Wednesbury. It for me is important because Mr. Justice Holgate finds that the rationality argument succeeds, and that isn't often, or certainly not always, the case. So it's a good example of rationality Wednesbury winning. It has further value. That's why I want to encourage you to read further. In paragraphs 146 to 163, there's a detailed discussion of another burden hurdle to get over in public law cases, and that's in section 31(2)(a) of the Senior Courts Act 1981, where the courts are prevented from giving a remedy if they discover or find that it's highly likely, quoting from the section, that the outcome for the applicant would not have been substantially different if the conduct complained of had not occurred. Now, that's dealt with by Mr. Justice Holgate with a fairly robust approach. Particularly, he refers to the Plan B Earth case at paragraphs 153 and 161. Really well worth looking at, and the emphasis on the rule of law. The second point, which is the one that Stephen touched on, and I can be very short on this, is Katherine has referred in detail to A1P1. I wanted just to mention in climate change cases that the European Convention of Human Rights can provide arguments at national level and at international level for claims. And Article 2, the right to life, Article 8, the right to private life, have succeeded when combined with a duty of care, which may not work in our society, has been successfully applied in the Agenda case and more recently in the Royal Dutch Shell case, both Netherlands cases. The Royal Dutch Shell case is now on appeal, and as their system in the Netherlands is a de novo appeal, it might be years before we get the final result. But even more interesting is the case known as the Portuguese youth climate case. This is 6 young Portuguese children and young adults who have launched proceedings against all the states in the EU, plus Norway, Russia, Switzerland, Turkey, Ukraine, and the UK. So it's 33 countries, and that's gone straight to the European Court of Human Rights. The argument in summary: breach of Article 2, breach of Article 8, but discrimination because a failure to deal with climate change is more severely going to affect the next generation, the children and young persons. The state of that piece of litigation is the 33 states have been given time to put in their defenses, and today, 9th of February, is the date when the applicants put in their responses. I tried to find for you from connections with that litigation when the oral hearing is, but I haven't had a reply, but it's to be watched out for. That's all I wanted to mention in the couple of minutes I have spare. So thank you, Stephen.
Okay, thank you very much indeed, Nigel. There was one further, we've got a few minutes. There was one point that occurred to me, Katherine, listening to your presentation, and that was on the Npower case, about Npower being asked to carry out this trial of telling their customers that they could save money by switching to another supplier. And you can see how suppliers wouldn't be terribly happy being asked to do that. But it did occur to me there's another principle, isn't there, which may come into play at times, particularly where one's dealing with the implementation of law that has a European Union origin, which is equality. In other words, that like cases should be treated alike, and different cases should be treated differently. I remember doing a case in front of Mr. Justice Sullivan before he went to the Court of Appeal quite a long time ago, where we were discussing this. He wasn't terribly impressed by those European arguments, but I mean, I can see that in that sort of Npower case, it's not objectionable if all suppliers are being asked to tell their customers that, but it's certainly objectionable if one supplier is being singled out and being asked to act in that non-self-interested way. So I was just wondering whether any of the three of you had any thoughts about perhaps the development of those principles of equality in some of these issues that may arise.
Yeah, I mean, I agree with you, Stephen. Of course, it's now we're in a Brexit landscape, so it's sort of more, you'd obviously have to ensure that you have a kind of domestic standing for those sorts of arguments, and that will depend on the statutory context of your particular case. But in theory, absolutely. I think on that, in the Npower case, actually, it was a scenario where all the suppliers were being asked to do similar things, and actually there was evidence that this particular supplier had done a particularly small amount compared to other suppliers. So that wouldn't I presume have been the right factual scenario to run that sort of argument. But absolutely, if a regulator, a public authority picked a handful of companies that had to do really quite onerous things, and that couldn't be properly justified, then yes, and if that had, you know, serious impact on those companies' finances, then absolutely you'd be looking to run those sorts of arguments. Thanks for bringing it up.
Great. Dan, I'll just give you a chance. Was there anything you wanted to say by way of follow on to your session?
Thank you, Stephen. Only just to really add to Nigel's comments. I mean, I agree with you, Nigel, that they do bear reading, these cases, in a bit more detail. I mean, the point on Wednesbury, I wanted to just say two things really. One is, in a sense, we see examples in the cases I was discussing of, you know, claimants tend to win on that second aspect, if you like, of the Wednesbury test more often than not, rather more often than they can on the higher threshold of the first aspect. And I suppose that's the territory on which claimants sort of need to develop their cases, really, if they're going to, you know, and by contrast, obviously, offgem and authorities need to ensure that they are properly taking things into account and applying guidance and what have you, taking into account material considerations. The second thing I just wanted to mention briefly, and I related to Wednesbury, is I wonder if there's some scope. I mean, look, again, thinking of the Fordham judgment, or even the Holgate judgment, although it was perhaps unusual for him in some respects. But you know, is there going to be development in this area, you know, of the test? Target duties, for example. I think before we came into this session, we were talking about what the legal basis for net zero is, and often it's quite flimsy. Often it rests on have regard to, you know, need to have regard to duties, target duties or process duties. And I wonder if the courts might, some of the judges at least, or sometimes the court might develop that a little bit and seek to give it a bit more teeth as the urgency of net zero sort of increases.
Well, I think we can certainly say we're in for an interesting period to come because of these pressures. And I think an interesting question will be how far the courts are willing to learn from similar case law or case law on similar subject matter elsewhere in the world. That I think will be really quite interesting in the future. But anyway, we've arrived at, by my watch anyway, 5:45, and I said we'd finish by then, so I think we should stick to that. So I hope everyone has enjoyed it, got something from it. There was one very practical question that came from the Q&A, which is, can you get CPD points for this? And the answer is certainly yes. We're accredited as a CPD supplier, and you will get, as we've said, copies of the slides probably tomorrow, I think, from Beth in our marketing department. So I hope you've enjoyed that. Please do join us for future sessions, and please also be aware of the other resources that we have online, environment and planning newsletters, blogs. There's a great deal there, including previous webinars and so on, which can be important resources, I think, in some cases. So do have a look at the website if you haven't already. With that, I think I will say goodbye. Thank our three speakers, presenters, for their excellent presentations, and I wish you all a very good evening. Thank you.